Good morning, everyone. Thank you so much for joining us for our free Thursday webinar. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate in Queensland, and I'm your host today. Matthew Lowe from Kerin Benson Lawyers has joined us to focus on the significant changes introduced by the Strata Scheme Legislation Amendment Bill 2025 in New South Wales. Now, this new legislation is set to reshape strata living, so it's crucial for owners, corporations and all stakeholders to understand the implications. Matthew will provide a clear and insightful overview of these key reforms, including accessibility infrastructure, changes to legal mechanisms for unpaid levies, and responsibility for building maintenance. Our aim is to equip you with the necessary knowledge to confidently navigate these changes and prepare your owner's corporation for the future as strata living in New South Wales. As LookUpStrata takes our transparency responsibilities seriously regarding partnerships, I'd like to mention that Kerin Benson Lawyers is a long-time sponsor of LookUpStrata. And as I mentioned at the beginning of the session, in addition to owning LookUpStrata, I also own Tower Body Corporate. Before we begin, I'd like to mention that the information in this session, including the discussions arising from submitted questions and chat conversations, is not advice and should not be relied upon as advice, and you should seek, as always, independent advice before acting on the information contained in the session. We welcome Matthew Lowe, Special Counsel at Kerin Benson Lawyers. So Matthew graduated laws from University of New South Wales with honours and has practised as a solicitor for over 10 years in civil litigation. Matthew is an active member of the Law Society of New South Wales and was appointed by the President to the Business Law Committee in 2021 and its Costs Committee in 2023. He was awarded Highly Commended Committee Member of the Year by the Law Society in 2024. So we welcome Matthew for joining us for today's session, and it's great to have you here, Matthew.
And thank you everyone for being here to talk about a very, very important piece of legislation that has come through. And before I go to the slides, I'll open by saying that there are many presentations already in respect of this particular piece of legislation. There's particularly good content from Alison Benson from Kerin Benson Lawyers in respect of this, and I understand there's newsletters that are being generated in respect of the changes in detail. The purpose of this particular presentation is to look at the legislation itself, some of the issues that might arise, because the legislation has lots of changes, a very particular impact, and what we hope to achieve is to give everyone a greater appreciation of what to look out for when it comes in. This presentation is in respect of Strata Schemes Legislation Amendment Bill 2025, which was only passed in February of this year, even though it was in debate a bit earlier. And the way that I've titled the presentation is New Wine in Old Wineskins. And it's trying to adopt a lot of changes to a very significantly developed system in respect to strata. And the question remains, how is it going to work? The question remains, is it going to do what it wants to do? And if, in terms of not doing that, what issues to look out for? And as it's outlined here, the aims is to introduce it, give everyone a good understanding of some of the key pieces. It's not intended to cover every single change, and to discuss the implications. Now, when I explore and look at legislation, I really like to look at, firstly, what the bill was intended to do. And before we talk about the actual changes itself, it's very difficult to see if it's achieving its goals without looking at what the government claims it's supposed to do. The problem, however, is that generally laws are written in such a way that it creates unintended consequences. And so the purpose here is we're going to look at whether there are such, or pay attention to potential causes that could lead to unintended consequences, particularly in those 5 areas outlined: the accessibility infrastructure, the levy recovery, the maintenance obligations in respect to common property, executive committees, scheme committees, and also enforcement provisions in respect that powers that would be given to the secretary, aka Strata Commissioner, or rather alternatively the Strata Commissioner, in respect of any breaches by owners corporations in respect of the common property obligation. So I'm going through this typically in a grand overview. I will go into it in much more detail as I arrive at each of these points. Now, the purpose of the bill is this Strata Schemes amendment bill is detailed in the second reading speech. The second reading speech is what the government presents to Parliament and explains what they were hoping to achieve with this bill. Now, I first start by saying that there has already been an amendment that was put in earlier in around that was passed around August, September of 2024, but which only took effect in February 2025. And that was the one directed at strata managers. And that followed from the reporting in respect of strata managers in the press, and the government had passed the strata manager amendment bill, now Act, which has been incorporated in part into the Strata Schemes Management Act. So that particular bill was particularly focused on strata managers. Subsequently came this bill. Now, this bill was already in the works when that bill, the Strata Manager Bill, was put up. This bill was in the works following a review in respect of the Strata Schemes Development Act and Strata Schemes Management Act that had already been conducted and various recommendations put up. So this is a culmination of that review. And it is much more expansive than the previous one. Whereas the previous one was dedicatedly focused on strata managers, this particular bill is generally going to affect the relations between everybody that is participant in strata living, owners corporations, committee members, lot owners, strata managers, building managers. Everyone is going to have some be impacted somehow by this change. So this is a much more expansive bill, and its focus is intended to improve accountability, intended to manage services, as highlighted, bolded, emphasized of this in the text quoted here in the second reading speech. And the real question, therefore, is, does it achieve those goals? And does it achieve making strata living easier? And how could owners, corporations, executive committees, and lot owners utilize these changes to improve strata living as intended? So that's what the government says it's to do. Now, the thing about the law of unintended consequences is a concept that, and I have a quote here from Stephen Reynolds, who is a deputy clerk of the Parliament of New South Wales, which talks about the fact that whilst a lot of laws are passed to do certain things, what it ends up doing, because of drafting reasons usually, is that it has unintended consequences. And the difficulty with that is sometimes the unintended consequences are so entrenched that it needs a new law to be changed. Sometimes the courts can change it. It takes a lot of work to do so, but it's definitely a phenomenon that is so well known that it has its name, the law of unintended consequences. And this is something really important for people in the public policy space. But for our purposes, what we need to understand, or what this is trying to present, is that whilst the Act claims to do something, the real question is, does it do those things? And even if it does do the things that is claimed, does it do other things that was not expressed in the terms of the Act because of how it's worded? Holes are not loopholes are not closed. Issues. Now, keep in mind that this legislation, as it stands, is not going to be the final piece of these reforms. All of these reforms are not yet implemented into the Act. It is to take effect, although it is approved by the government's passed by the legislature, it hasn't actually come into force. And there's an indication that there would be significant regulations that would be attached to to follow from this legislation. So the question remains, could it be addressed in the regulation? So that's what we really need to look forward to, and we need to pay good attention to that. And in the meantime, what we're going to talk about here is that there are going to be some parts of this legislation where we aren't going to know exactly how it's going to operate, and there are some likely unintended consequences should these regulations not make things very clear. Now, the first one I wanted to, of the items that I wanted to raise is the accessibility infrastructure. Now, the intent of this, according to second reading speech, is a noble-minded endeavor. The idea is that, like the sustainability infrastructure that was passed a little earlier, not in 2024, before that, the accessibility infrastructure in terms of different abled individuals. The difficulty of changing common areas, common property, requiring a special resolution, the government felt was a barrier for individuals who required these accessibility infrastructures. They would need a supermajority in order to get these changes through. And what the government wants to do is to allow that kind of infrastructure to be able to be passed with a simple majority, as opposed to be a special majority. The issue, however, is that there is not a very clear definition as to what accessibility infrastructure means. I've reproduced on the screen here what exactly accessibility infrastructure means. Now, accessibility infrastructure resolutions in effect just means any resolution to create the accessibility infrastructure. But if you look at the definition of accessibility infrastructure, it merely states that it is changes to any part of the common property to facilitate a person with a disability having access to the common property or the lot in which they reside. Now, this is a definition that is one of those definitions that lack any content. It sort of answers itself. It's almost a tautology. Well, you can just say, well, it's infrastructure to assist disabled people having access. Well, but what does that mean? And that is where I would suggest that there is potential to be significant dispute that arises. Imagine somebody puts up a resolution in respect of the purport accessibility infrastructure, and it is passed, resolved with a simple majority of, for the sake of argument, 51% of the unit entitlements. Somebody else not agreeing that that particular resolution was in respect of accessibility infrastructure, arguing that that thing is not accessibility infrastructure, would likely challenge that and could lead to dispute at the tribunal, could lead to appeals at the tribunal, arguing over whether it is accessibility infrastructure or not. For example, in an older building where it is not possible to install, where there are stairs only, and if someone resolves to install completely up in the building, install a lift, well, would that be accessibility infrastructure? It's not clear. One would think so, perhaps. Some others would say, well, that doesn't seem like merely to facilitate a person having access. They already had access. What if somebody, a person with disability, was only residing on the ground floor and they had no real need to access upper floors? Now, all of these are hypotheticals. Regulation will clarify exactly what this definition means. And none of the examples I've just given was intended to illustrate how the disputes are going to go down, if indeed there are any. But the purpose of those examples was to illustrate how accessibility infrastructure as a concept is obviously a very noble cause indeed. You know, you want to be able to make it easier to allow access for people with disabilities, as outlined in the second reading speech and in terms. But what would that entail? To what extent would it fall into that definition, right? And indeed, making a unit, an apartment into townhouses would also be able to assist in access, but that would obviously not be what the intent of this legislation is intending to do. So that's what I mean when I say it will come down to either clarification or, in the alternative, regulation to clarify. Now, this is not merely a hypothetical suggestion that there could be disputes. And I would draw to the next slide a reference to the very parallel changes that had happened earlier in respect to sustainability infrastructure, which is about renewable energy, pollution reduction infrastructure. That particular kind of infrastructure already has incorporated in the Act the requirement only for a 50% majority resolution to be adopted. And in that case, in respect to sustainable infrastructure, the definitions are much clearer than in respect of accessibility infrastructure. And even then, in those cases, there have been disputes. Now, in the particular dispute I mentioned up there, laws against the owner's strata plan 97230, my observation of that is that the argument was probably stemmed from just not liking the particular infrastructure being proposed. It wasn't, in my mind, the highest level of challenge to definitions and stuff of that nature. But it just goes to show that even where you have a very clear definition about something, people might still have a big fight about it over whether a supermajority was required or only an ordinary majority. And where there is even less of a definition, there's likely going to be a lot of issues. So I think the thing to look out for is A, whether there are going to be regulations, and B, if in fact there is going to be no clear regulations coming in, and it's just the definition as we have it, then people ought to have to think very carefully about what might happen if accessibility infrastructure is proposed, and there might be challenges to whether it even falls into that category. And unfortunately, we don't have an answer today. Unfortunately, all I can say is we have to watch the space and be mindful. The next category is in respect of levy recovery. Now, I put here in the slides the second reading speech text, again from the second reading speech, in respect of what is attempted to be done in levy recovery. And the main focus here is that the emphasis is that they want to ensure that owners corporations are going to be allowing payment plans for lot owners who are unable to pay their levies due to financial hardship reasons, and that the default is that they must offer payment plans, and that it can only be refused with cause, with reasons, as opposed to, well, we just don't want to offer a payment plan. And that is what is attempted to do. And as the second reading speech mentions, it is because there is a concern that levy recovery, particularly levy recovery action, is adding to individuals with financial hardship. Now, there's obviously going to be issues with that, which I'll touch on, but let's just take a look at some of the implementation that is going to be put through. Now, what was introduced in the Act is an increase of clarity in respect of what the levies are for, clarity in respect of payment plans being an option available for people if they are not able to pay entirely the levy upfront, and that there must not be a situation that the owner's corporation can either have by some resolution to not allow payment plans, or nor are they allowed to refuse payment plans unless they have good reasons. What that means at this stage is still unclear. The regulations will clarify what is reasonable refusal for payment plans, but the intent is obviously that there must be some explanation as to why it is refused. Whether it passes the bar or not is to be determined by the regulations. And if there was to be an unreasonable refusal, then the tribunal can just make an order in the alternative to substitute for. And all of this reforms, including talking about identifying evidence and payment plan, all of this is to create a regime where the levy payment plan system is one that has what would be termed procedural fairness, where although it's usually a thing referred to government decisions or courts, they're basically applying, and it's not a term used here. This is the kind of structure we're seeing, procedural fairness, where if I'm telling you you have to pay the levy, in other jurisdictions, you deny, say, an insurance claim, they would have to tell you that you can lodge it at AFCA. They can tell you what time you have to lodge it into CAFCA, and they will put it at the bottom of their letter. Likewise, what is being proposed here, although we haven't seen an example of what it looks like and how it's supposed to be structured, because it's to be introduced in regulation, is some mechanism that says financial counseling, you need to think about that. There's payment plans if you can't pay. we have to give you the reasons if we refuse the payment plan, so you can challenge those reasons, etc. So that regime is all again done in good spirit, in a noble spirit, to help those in financial hardship. Additionally, there is a restriction on debt recovery. So there has been a lot of coverage in respect of debt recovery from owners corporations in respect of unpaid levies. And again, the emphasis is that debt recovery action is not to be taken as even a second or third resort. Payment plans are the dominant mechanism, and in fact there's a prohibition in taking such recovery action whilst a payment plan is in place. There is some legislation here to cure the situation where historically it was unclear that if in the midst of unpaid levies, the lot owner then did pay some monies, whether it would be applied to the unpaid levy or whether it would be applied to the interest. And this makes a difference, because if it's only applied to the interest, the principal is still there and it still accrues interest. And so the remedy has been made clear that it must first be applied to the contributions to the due date of the levies. And so that means you would be paying off levies first and then moving on to interest. And finally, there is an indication that the costs of recovery of the levy debt cannot be, rather, I rephrase that, in respect of costs for the debt recovery scheme, the owners corporations cannot recover those unless there has first been an order made by a tribunal and court, and that there was an offer of payment plan, and that was not carried through. So the idea would be to restrict litigation as an option. It detracts, reduces the attractiveness of litigation, because you need to have first offered the payment plan to even get your costs. You cannot start it without having made the offer. And all of this is to reduce the attractiveness, to encourage people, owners corporations, to offer those payment plans, and requires those owners corporations to give due consideration to, if they were to deny payment plans, they have to give good reasons. Now that's all well and good. That's to deal with the those who are in financial hardship. The problem about, as I mentioned before, is that this regime is changing the relations between owners, lot owners, owners corporations, executive members, and so on. So this represents a shift in the relationship. So whilst this shift that gives more protections to the lot owners and reduces the power of the owners corporations to take litigation, you can also see issues that may arise. Now, firstly, it remains unclear as to what reasonable means. And in the law, we often use this term reasonable very, very frequently. And we observe that reasonable tends to be the thing that people fight about. What does reasonable mean? Worse is because reasonable people tend to be able to disagree. Now, the test usually is that reasonable is, if a large number of people of sound mind would think one way over the other way, it's take a poll, then a straw poll of that and the majority goes one way, sure, that seems easy enough, but in practice, you don't have such a system when you make decisions. Even if were to introduce, it will be after the fact. So sans any regulation that explains what reasonable should mean, leaving it just to a commonsensical understanding, you put 10 people in a room, they will have 10 definitions of what reasonable is. They might have commonalities, but they will have some differences, especially when it comes to the pointy end, especially when it comes to specific issues. So definitely that is an concern. What would be a reasonable refusal for payment plan? We will have to find out, and hopefully it wouldn't lead to need to go down tribunal routes, because that will only cause more issues. Hopefully the regulations will clear that up. The second thing is, whilst we accept that there are lot owners who have financial hardship, we also know that there are those owners that are just levy truants. They never pay levies. They're delayed. Now, this system doesn't prevent the owners corporation taking action against those insurance lot owners. But the issue here is by taking away some of the teeth, the penalty, there is no consequence for delayed payment, it would seem, unless the regulations clears it up. It would seem from the changes as it currently sits, if it's implemented, someone can delay in payment. You have to first offer them payment plans before you can even sue them. You can't sue them for interest. You can't sue them for cost. Once they agree, you have to give them good reasons to not accept the payment plan. They just delay. They take a payment plan. They delay the payment plan, and then you have to again negotiate with them before taking action. And unless you take it all the way and have an actual order in respect of costs, you can't get your costs. So what would happen to those delinquent levy payers? Would they be able to just get away with delay, reducing the resources of the owners corporation, requiring the owners corporation to expend more in order to address this, or indeed to raise higher levies in order to adjust for this impact? Now, this again is just a consideration. The regulations might clear this up a little bit, but where there is no consequence for delay payment, and again, if they delay, you still have to first offer them a payment plan, and there's no increase, there's no cost penalty, and you have to offer them a payment plan before you even take any action. Well, would that likely encourage some lot owners who are not responsible, not the legitimate ones with financial hardship, to want to utilize this mechanism to their advantage? Possibly. So maybe the regulations would clear this up. Now, indeed, this is recognized in the second reading speech, although there doesn't seem to be much implemented to address this particular concern. And you can see the quote down there. Even the non-payment of levies can be a significant issue for strata and community land schemes. If levies are not paid on time, there can be detrimental impacts, particularly if the levies are for urgent or necessary maintenance or repair work. So whilst the government in passing this legislation acknowledges that the non-payment of levies can be an issue, they have struck a balance, which is we are particularly concerned with financial hardship and owners corporations taking too strong a hand in respect of financial hardship. Whether this particular change now strikes the right balance, time will tell. But I think for this lawyer, I would say perhaps some regulations tilting it a little bit back a little bit in order to make sure that it's only those with financial hardship as opposed to the delinquent ones. That would probably be something that the regulation should consider, not that the government's necessarily listening to me. Now, the next set of reforms I want to touch on is in respect of the maintenance obligation, Section 106. Now, the particular concern that was indicated in the secondary speech, outlined in the review that went into these current reforms, is there are concerns that many owners corporations are delaying in performing the maintenance obligation. Now, whether this is the case or not, I don't know, but that is a concern that the government wanted to close. And it would be if, in fact, there was lots of issues in respect of failure to maintain and the general common property obligations, then yes, there is definitely, that's definitely a noble cause. Now, firstly, one of the things that was implemented is that the deferral in respect of Section 106 of Section 4 has been expanded. So as you know, under Section 106, the obligation is continuous, but there is a deferral allowed where parties to take action. And I just realized I just spoke. The exception to the deferral has been expanded, is what I wanted to say before. So historically, if an owners corporation was taking action, presumably against a third party in respect of maintenance issues of the common property, they have a deferral to rectify the issues, unless that those issues have some sort of structural impact or impacts the appearance of the building or something of similar kind. That has been increased to include if it affects persons' access to or the use of the common property or a lot property in the scheme. So it's not just structural issues or appearances anymore. That does not allow you to defer. You must fix those promptly. It's also access you must fix, asset access issues that you must fix promptly, and you cannot defer it by saying that you are taking action. Now, this follows in line with the accessibility infrastructure. It's trying to in part deal with greater access, but it's not dedicated towards people with disabilities. It's general access in this sense, but it's the same kind of idea that you don't want to be certain individuals to be restricted in access somehow to property for legal reasons. But if you can look at the definition there, and I'm not sure I've quoted it exactly, but it's pretty much near verbatim in terms of what the scope is access, a person's access to use or use of the common property or a lot in the scheme. Now, I can understand what that is trying to do. There's a common property passageway to a lot. There is some defect, maintenance issues of that common property. You are no longer allowed to defer the maintenance if this prevents someone to access their lot. But by definition, if you're just reading it literally, anything, mild or not mild, can somehow affect access, a person's access to any part of the property. Any defect could potentially have that scope. So does this mean that the section 106 subsection 4 is now rendered completely useless, completely otious, that you can't defer anything because anything could potentially affect a person's access? Well, this again is where we are concerned at some of the implications there. By being so broad, the government leaves it open that they can put the regulations in to narrow it. But as it stands now, until the regulations comes in, right off the top of my head, I can imagine an argument that can be made for almost any problem, especially from the ones that I've been dealing with, say for clients or for owners corporations, that could fall within this definition. And then the section 106 subsection 4 becomes basically unable to be engaged ever. Well, that I don't think will be the case, but how wide is this affects a person's access to and use of the common property or lot property in the scheme going to be? That will determine what the implications of this actual change is, and we'll have to pay very good attention to the regulations. Another change to section 106 is in respect of the limitations period for so this is subsection 5 and subsection 6 issues, which is if you have a maintenance, a common property maintenance failure that has led to a loss, the historical period, historically limitations period for a lot owner to recover, seek damages for that loss was limited to 2 years. After 2 years, you cannot raise the case again. It's out of time to bring. They have now extended that to 6 years. Now, you can already see the issue of what such a dramatic extension would have implementation-wise. Well, when is it supposed to take effect? Is it for building defects that were noticed? Rather, was it for losses that were noticed as the time it was passed? Was it for losses that existed before, would have passed the 2 years, but would not have passed the 6 years? Or is it only after the fact? Well, but how would that even work? 2 years to 6 years is a dramatic jump. Now, usually when legislation comes through with massive changes to limitations period, massive changes to timeframes, there's always a mechanism known as transitional clauses, which would be introduced to the act and then phased out. Now, I envisage that that's what's going to come in the legislation, rather the regulation. But at this stage, all it is saying is it will go from 2 to 6. From when? Losses from what date will go to 6? We don't know. Is there a gradual increase period so that no one's disadvantaged and people have more notice of it? I don't know. We will have to find out. Usually what happens is there's gradual increase until it gets to 6 so that no one's disadvantaged. And after a certain date, it will be 6 years ongoing. Now, we will have to see. But if it was to just take effect on a certain date, then you can imagine how ridiculous it is. Let's say they decided on, the government decided on the 30th of June, 2025, it will still be 2 years. On the 1st of July, it will be 2025, it will be 6 years. So if you noticed a defect on the day before, it would only be 2 years. If you noticed the day next, it'll be 6 years. That's usually a kind of change that causes chaos, because detecting a loss is itself a questionable statement. Like, when did you notice it? When did you become aware of this loss? That's why transitional schemes tend to come in, and we'll have to take a look at what those regulations say. Again, something to pay attention to. Some additional changes, which probably won't have as dramatic an issue, but is intended to clear up matters. So, for example, special resolutions for alterations to common property, particularly if it was a lot owner wanting to do something in their adjacent common of their lot, all these special resolutions now must specify to whom the maintenance obligation, who holds the maintenance obligation. So historically, a lot owner puts up a resolution, they need to make some changes that involves the common property. It's approved by the owner's corporation. They might have had an agreement as to who was meant to maintain this change, or where the boundaries were. It wasn't clearly recorded. Chaos down the line. This change has now been introduced, and this is in some sense very similar, although not exactly the same, as when back in respect to the 1996 Act, when they introduced Section 65A in 2006, because again, it was not clear where common property changes were recorded correctly, what the change was supposed to be. That now 65A made it require a special resolution. That has then since been incorporated into the 2015 Act, and actually, I think under Section 108. So this now just adds to that by ensuring that the maintenance obligations, again, are more clearly recorded. And so that is I don't envisage any unforeseen circumstances, but if I could foresee it, it would also not be unforeseen. But that seems a straightforward change. And another change that follows from the timber of this procedural fairness thing that I mentioned earlier about payment plans is in respect of minor renovations. So historically, the concern was people were putting up requests for minor renovations, owners' strata committees were taking very long to consider them, and they were not being approved. And that is definitely likely to cause some concerns. So what has been introduced is that there is a deemed acceptance should there not be an open refusal after a 3-month period of submission, and there must be better record keeping, and also reasons must be provided. So again, if you reject minor renovations, well, historically there were no reasons, so you don't know how to challenge it. You don't know, well, what is their concern? How can we meet those concerns? Now the reasons must be provided. But again, it remains. There's already this might itself cause disputes as to whether those reasons were satisfactory or not. But this is definitely an addition that would definitely protect lot owners more, with allowing procedural fairness in this space. But it would make it incumbent on executive committees to make decisions more promptly. And that's a large part of these reforms, which there's more coming up, which is about the committee is held to more account. But we haven't got there yet. So yes, I mentioned briefly about these potential issues, and I'd forgotten to jump to this slide when I was talking about them. But as you can see, as I mentioned, the scope of 106 subsection 4 is rendered so wide, the exclusion is rendered so wide, well, this makes section 106 subsection 4 basically ineffectual. And the question about 106 subsection 6, and also there would likely be some disputes perhaps in respect of the minor renovations when people are still trying to get used to the scheme. But things that regulations can cure, things that good legal advice probably can also cure. And which brings us straight to the executive committees. Now, I use the term scheme committee here because that's the term used in legislation, but executive committee is what I mean, or strata committees. Now, the second reading speech, based on the report that went into it, suggested that some committees, not all, were not doing their job well, and acknowledges, while most members, or they say many, but I would say most members of executive committee take their duty very seriously. They discharge their duty in the highest of obligations. I have still, no doubt many of you would have seen some exceptional circumstances where some members are not carrying out their duty as they should and are falling short. And all it takes is one to really damage a scheme. It really takes one. all the good people can be undone by one. And what is trying to be done here in this reform is to increase the obligations in respect of committee members. It expands what they are required to do. So they already currently have a statutory obligation to conduct themselves with due care and diligence, so to speak. Well, that's what as far as practical. But what is expanded to is additional obligations for honesty and fairness. Potentially additional regulations will prescribe specific conduct. Would that involve a code of conduct to be mandatorily implemented? We'll have to see. But there is also increased obligations for disclosure, and that the behavior must not somehow affect other people's use of the lot and common property. So the idea then again is, yet again, is they were seeing allegedly the some committees using their powers to delay, deny, make difficult access, make difficult enjoyment of property, and that again falls into this piece which was already dealt with a little bit earlier with respect to the minor renovations. They're trying to reduce the ability of the committee members to take such steps to make it difficult for some other members. However, and additionally, before I say it, however, is that there will be a requirement to take compulsory training and that is not clear what that curriculum or curricula, if it's various, would look like. There's no clear indication what it would include, but and that's again to be determined. So there's two aspects here. Obviously, we want to make sure that when the training implementation is put out, that the training is of a kind that would be both accessible for lot owner, incoming committee members, but also one that would cover the field, and that's a tougher task than. But if only the government talks to LookUpStrata, they'll have all the content they need. But the thing that is of concern is that there is, on the one, this particular reform attempts to reduce the ability, the power, in some very narrow sense, by imposing these obligations on executive members, but more specifically imposes greater obligations and imposes greater prerequisites, shall we say, to executive committee members. And the issue here is, on the one hand, the question is, would this increased burden actually lead to a decreased uptake of being committee members by the good ones, the people who are willing to discharge their duty on a voluntary basis? There's already, as many of us know, a high difficulty to get people to take up the role of committee members. And they are already, those ones who do their absolute best often get a lot of abuse as well, and take on a lot of responsibility. And with an increased obligation, would there be accusations they're not performing them even though they are? Would that lead them to not want to participate? Simultaneously, would these changes really prevent those people who would not carry out their duties in the first place to still volunteer to be executive committee, right? Someone who's fully responsible, wants to do their job right, 99% of the population, they go, I will do the job right. And they look at the job description and say, hey, this is a bit too heavy for me. I'm not going to put my hand up. The 1% who doesn't care anyway goes, I don't care what the obligations are. I'll put my hand up anyway, and I won't perform the obligations. Now, is that going to go down that way? We don't know. But that is definitely a concern that we should be paying attention to. And I think there's nothing that goes further than where someone is doing the job, where someone's doing the right thing, for owners to really back them and encourage them. Because if they're doing the right job, you might think they know that, but them knowing that they're appreciated goes a long way. So that ultimately these are democracies. No matter what regime you put in, if people don't find it is something they feel is rewarding, there's probably going to be a detraction to take it up, except those people who don't care. So you want people who care. What ultimately, I think, being encouraging, being supportive of them, where the ones who are doing the right job will probably be the most effective in ensuring the right people get up there. And it remains the case that there is no penalties for people who, executive committee members who breach their obligations. There is some removal mechanisms, which I'll talk about later, but if there is no penalties, well, what really is the consequence that would scare those committee members who are not performing to now perform? What would they? They'll send them an angrily worded email. So what? Perhaps we will have to see. Now there are obviously some additional penalties that are incoming in a separate part, which I'll touch on, which is in fact next. But those don't just apply to committee members. So whilst yes, I say there's no penalties, and there are some penalties that might apply to committee members, they're not dedicated towards committee members nor dedicated to their breach of obligation. Those are in respect of the enforcement powers of either the commissioner or the secretary. The statute says secretary. It usually gets delegated down to the strata commissioner or the relevant commissioner, whether the strata commissioner, how they're going to function or operate that particular mechanism, or we will have to see. But for now, the proposal in the legislation is that there will be penalties, but it is not dedicated to committee members. So there remains no dedicated committee members penalties for those committee members who breach it. So we will see whether that will be a deterrent where there is in fact no consequence. The final, let me just check. Indeed, it is my final. Yes, it is the final topic of this long this presentation. I hope everyone's still with me. No, I know everyone's. This is very significant information. The enforcement provisions that will be introduced is to give the Secretary of New South Wales Trading or Strata Commission, however it's structured. Currently it uses the term New South Wales Fair Trading, or in parts Secretary, but it means the same thing. It's under the department, the department secretary. The office of that is New South Wales Trading, of which could be the dedicated commissioner. They will work it out in the regulations. One of these entities will carry out enforcement powers, and mainly these powers are to do with the failure of owners corporations to perform their 106 obligations. Now, historically, we know how it goes down. 106 obligations not comply with, maintenance not, repairs not done. So the interested or affected lot owners would file at NCAT, and that would be disputed, challenged, fought, and I guess the concern is that the process of doing that is not, because of the adversarial nature of it, may not be as quick and prompt as if it was done by the government. And so the idea is that the government will create the powers that it will need to carry out investigation of and issue orders for the maintenance and repair of common property where there has been a breach. Now, some of the changes that are outlined here is, again, still subject to regulations. We don't know how wide these powers are. There's a wide ranging of powers to make orders, to basically giving them various options to rather generally gives them a power to do these things. We don't know what exactly, how wide it would go to ensure delinquent schemes that aren't maintaining the property, repairing the property, will be ordered, can be ordered to do so. The powers are also expanded to be able to have investigatory powers. So it's one thing to say, I can order you to repair. Well, how was I able to find out you weren't repairing in the first place other than the complaint? So attached to that is a massive investigatory power. In the sense, it's like a owners corporation strata scheme repair investigator. Really, they will go in, they would have the powers to investigate, get records, get information, and they can just issue these orders at their discretion. And they can require all sorts of things be done, be it documents being provided, that the scheme must answer certain questions. They can even apply for search warrants or access orders. Basically, they would have far-ranging investigatory powers. And they can also then issue compliance notices. And ultimately, what they're hoping to do is, however, to not have to issue these orders And so they still have this option where they can accept from the owners corporation undertakings that they will just do what is perhaps suggested without having that be made in order, as long as that is approved, authorized by a special resolution scheme subsequently. But I highly doubt where if an owners corporation is looking down a barrel of a compliance notice or some kind of work order, that they would not resolve specially to accept an undertaking of similar kind. But who knows? But the answer is the change merely gives a massive range of powers to the commissioner or the fair trading or the secretary to do all of those things that would lead them from a notification of some issue with maintenance, investigation throughout, and culminating in some sort of order. Now, they still can be challenged. They can still be challenged and appealed, but that's always a possibility. But this means that they, with their massive resources, are at the forefront. They don't have to go through an adversarial process to issue this order. They're basically inquisiting. They're basically the commissioner. They're doing their things, finding out. They make the order. They make the decision, and their word is subject to appeal. The final word, subject to appeal, of course, to tribunals of the court. However, whilst they have such powers, and I use the word absolute discretion, and they do, right? That actually could be a double-edged sword. Because the Secretary or Commissioner of Fair Trading has the absolute discretion as to what complaints to take up, as to what investigations to take, as to what orders to make, and in the current legislation, there is no indication of standing. Standing is a term that says if there's an issue you feel strongly and you want to make representations on, you need to have a basis to be a person who can complain about these things. And so, for example, if it's a court case about some contract dispute, not any person can just walk up and say, I also want to talk about this. You need to have standing. You have to have some connection. Now, these powers are statutory. You can say you have a standing in the sense that you're involved in this, you made the complaint, but the Act doesn't actually create that. The Act doesn't say you can make it, you can give a representation. It doesn't say that the Secretary has to consider your representation. The Secretary has absolute discretion on where the direction the investigation goes. They decide where it goes. They decide what orders to make. And sure, you can make some representations, but there is no requirement that they consider it. And in that sense, it's that this is actually not that different from some of the building commissioners' investigatory powers at the moment, where the issue is also that there is no standing. The building commissioner just makes an order in respect of building defects, work orders and such, where no feedback needs to be considered. Likewise, that seems to be what is proposed. And there will be a question as to what, if lacking that input, that the remedies being proposed by the commissioner, by the fair trading, by the secretary would be an appropriate one. So, and perhaps there could be the possibility of standing in the regulation. So we'll have to see. But ultimately, if someone's making a complaint, the person making the complaint would probably hope to be able to make some recommendations about how it's going to go down. And if the commission is not required to consider it, that may be a hole there which needs to be filled if possible. There is the power to issue penalty, and it is extremely wide. It is extremely wide because it is not restricted to the owner's corporation or the Strata manager. It just says any person. Now, the reason it's so wide makes perfect sense because it's arising from investigatory powers. They're saying, we want to investigate an issue. We can issue warrants. We can issue access orders. Anybody could stop our access. So we don't have the penalty to fine anybody that blocks our way, anybody that prevents us getting the documents, anybody that gets in the way of us carrying out a function, then our penalty powers can be easily circumvented, perhaps, by some third party. So I get that, so that is an additional power. Now, obviously, I would envisage that they would use it sparingly, but keep in mind, it is very broad, and it could include lot owners and even tenants. So just keep that in mind. It's this power to investigate the common property maintenance failure The investigation powers, which have penalties if you don't cooperate with them, they can extend to a tenant, a lot of it. Indeed, any person, but most pertinently would be those. So just keep that in mind. It's not only directed against the owners corporation, not only directed against the committee members, not only directed against the strata manager. So, and with that, I think that is the substantive part of my presentation. I hope I have been informative and been able to give everyone a good sense of some of the changes that are coming through, some of the key ones that I think are very important to owners, and given an illustration of some of the concerns that you might want to, some of the issues you might want to be focused on and perhaps concerned about, but noting that this is not the final piece. Regulations are coming, but keep close attention to it, because it's not set in stone what this is actually going to look like yet. There's a skeleton. The substance is going to be what the regulations say, and I hope everyone will be ready, at least more prepared for it when it comes.
Thank you very much for that presentation. Lots and lots of detail. I think everyone would agree it was fascinating to go through the particular points you pulled out of the bill in such detail and explain that to everybody. What specific costs must be itemised in a strata building insurance quote, and does this include commissions and fees?
That is an excellent question. It's actually not in respect of the current strata schemes legislation amendment bill, which has come through. That is actually addressed in the strata managing agents legislation amendment bill, and that's already come into force, which is the section 166 change. And I actually have it in front of me because I got this question earlier. So, and it's in the subsection 2 that came into force, I think, the 3rd of February. So a quotation, and I'll just quote verbatim, must include a breakdown of the charges, including the base premium amount, other than an amount referred to in respect of the commission. The commission, other than any broker fee expressed as an amount and a percentage of the base premium amount, the broker fee, again, expressed as an amount and as a percentage of the base premium, stamp duty, levy, underwriter fees, GST, and any other additional charges that would be prescribed in the regulation, in which presently there's none that I'm aware of. So that's in force already. So that's section 166 of section 2.
The legislation covers strata managers, but does it also extend to building managers?
There has been an expansion in respect of building manager obligations in this current reform. Effectively, they have some of what applies to strata managers now applies to building managers as well. That's introduced in the latest one, this current amendment, but it's not actually enforced yet. So there's already some disclosure requirements in respect of connection between strata managers and building managers that was introduced in the strata management agents legislation. I know there's too many legislation to get confusing. The earlier one in August, September 2024 had already required some disclosure obligations in respect of building managers being connected to strata managers, but it's really more incumbent upon the strata manager. And now the changes that are to come into place places upon the building manager some obligations.
Will New South Wales Fair Trading collaborate with NCAT to enforce the penalty if a strata manager's licence is cancelled?
I can't really speak to how far the New South Wales Fair Trading is intending to collaborate with NCAT. I mean, if there's an NCAT order, how far New South Wales Fair Trading will cooperate with NCAT, that's executive decision, that's a budget decision. Obviously, I hope New South Wales Trading is always cooperating with NCAT, keeping good records, making sure there's a record of who's been whose license has been cancelled and so on. But I can't speak on behalf of Fair Trading, unfortunately. But I definitely endorse greater influence by the Fair Trading with basically making sure the whole regime works. And indeed, that some of the changes now does envisage increased participation. Whether that involves that particular step, I can't say.
What can I do now to prepare for these changes before they come into effect?
That's an excellent question. I think first is familiarize oneself with the changes as they currently stand, and keep an eye out for those issues that I have mentioned, and perhaps other issues that other people detect which are unclear. And a good identifier is where they says, and other subject to any other regulations prescribed or words to the effect. But that basically means they've created this regime. It's a skeleton regime. they're going to add stuff later. So if you're not even read up on the actual change itself, it will be much harder to read up on the regulations when it comes in because the fund is not clear. But unfortunately, it's impossible to prepare for the unprepared, for the unknowable. You may be, no doubt the government, when the regulations are going to be put forward, will perhaps seek consultation. There might be some circulation of that beforehand. Sometimes they give no, as the shortest of period, however. So I think the only thing I can say is be familiar with the actual substantive legislative changes that is proposed and enforced but not implemented yet. So it's passed, but they haven't actually set a time when it's come in, and just be ready for it, be aware of it, so that when the regulations do come, you won't be going, what's all these regulations about? You will be aware. So that's all I can say. And I'm sorry I can't give a stronger explanation, but these presentations, watching these presentations, being familiar with these presentations, being aware of this issues generally is the best way to stay aware and to be ready.
Okay, wonderful. Thanks so much, Matthew. If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.